Hey guys, Thad Torix here from the Torix Realty Group, and the point of this quick video is just to explain for you. So I've got my house under contract, or maybe I'm shopping for a house right now and it's about to be under contract, or maybe your house is on the market and it's about to go under contract, or you hope it's about to go under contract. What does that mean? Under contract is a fancy way for us to say we have a deal. We have a deal that we have agreed to in writing, and there are signatures in place binding one another to this deal. Like most contracts, this contract is going to have all sorts of details or contingencies, all kinds of ways in there where you have some protection. And as you have protection, so do the other side of the table, or the folks that are on the other side of this transaction. And so I want to just quickly outline for you a handful of things. I need to mention first, though, that I'm speaking for Missouri Real Estate. I am not an attorney. What I'm going to give you here is my opinion. I'm a licensed real estate agent, and the point of this is just to give you a starting point for conversation and discussion. And if you come up with legal questions, I want you to please reach out to me. I'd love to talk to you. There's my number on the screen. Or, of course, consult with your own attorney or some other real estate professional. So I'm going to bring up just the list here, and I've just called this what you need to know. And again, I'm not an attorney. This is not legal advice. This is just my 2 cents on what's important and what brings some confusion. So the first item here is, what's the effective date? The effective date is usually, depending on the wording of the contract, it is usually the latest date of the signature. So if you made an offer on a property on Tuesday, but the sellers didn't actually sign it, or maybe you went back and forth with counteroffers, it's not until you actually get that last signature that says we have a deal, that's the effective date. Keep that in mind. It is not the date where you first made the offer, unless by your good luck they also signed it on that same day. Earnest money is the next big thing. Earnest money is paid by the buyer. Some folks say that it's a down payment on your down payment, and while I can understand the simplicity of that, that's not entirely accurate. I would tell you to think of this as a deposit. This is you putting money where your mouth is. This is you saying, I'm going to put this money down, and this money says that I am taking this seriously, and I will not violate this contract. And if I do violate this contract, then this money that I'm placing in escrow, in earnest rather, should be given to the other party. Likewise, if the seller does something to violate the contract, then that earnest money should be returned to the buyer that paid the earnest money. It's not just as simple as saying I want my earnest money back and you get it back. Either side can dispute where earnest money should go, but ideally earnest money gets applied to the whatever is due from the buyer at closing. More information about earnest money is probably best obtained from the closing agent's office. Next is title commitment. Title commitment is probably the very most frequently missed item because it looks complicated, and it is complex, but it's not that difficult. In essence, a title commitment is the title insurance company, normally paid for by the buyer. The title insurance, the company providing that insurance is going to issue a commitment, and that commitment is going to say, hey, we will insure this legal description and everything surrounding it. Okay, when you buy property, you're really buying your right to what is described in the legal description. We will insure this against any kind of future claim. And then there's usually a list of either restrictions or exemptions, or maybe there's hurdles to get jumped over. Here's a good example. If there's been a divorce on the side of the seller, they may ask you to have some kind of paperwork done that assures that the divorced party that's no longer in ownership, that they don't actually have any rights to that property and that they can sell it free and clear. That's probably a common one that has to be addressed. When you see those things, don't let that make you panic. That just means that there's some item that has to be taken care of. You'll hear title companies call that a curative. It's some item that has to be cured with the property situation so that it can actually be transferred to the buyers. You may also find that there's other things. Maybe somebody has passed away. Maybe somebody who is an heir to the property has passed away. What you need to understand is that the seller has 10 days in Missouri, and you could adjust this on the contract whenever you issue it, but by default, the seller has 10 days to get the title commitment to the buyer. And that means that you should be able to review that. Once you actually have it in hand, buyers, once the buyer has the title commitment in hand, you have another 10 days for a total of 20 days to review the commitment. And that's time for you to say, I'm not sure that we can make this work. We're not satisfied with the title commitment. And that would be a time where if there's some condition that is not able to be resolved, then you'll have to approach that and see if it's time to walk away from the deal, or is there a reasonable plan that can keep things alive where you can take care of things. Sometimes court proceedings happen quickly, and sometimes they take a long, long time. So get with your real estate agent and find out what's reasonable. And if you want more information, ask for it. Let's get you in touch with the people at the title company that actually did the search. They're the experts. They're the ones who are going to say, this is what you should expect. Kind of at the same time is the inspection period. The inspection period by default in Missouri contracts is 10 days. I usually increase that to 15 days because everyone's busy. Home inspectors are busy, and it just takes some time. Things you need to know is, yes, you can call your uncle, the contractor, or your dad, the plumber, or whomever, to come and take a look at the property. However, if you're going to make an official request for repairs, you need to include a licensed official inspection with the inspection notice. They're probably not going to take the word of someone who, while they may be qualified, they are not licensed or certified as an inspector. So keep that in mind. We have 15 days. If it's contract I've written, it's probably 15 days. That 15 days is the amount of time that we have to get the actual official inspection notice into the hands of the seller. And that inspection notice is going to say one of three things. It's either going to say, A, we are satisfied and we are going to close the inspection contingency and we don't need any repairs. That's ideal. That's quick. It gets you to move to the next stage. B, and is probably the most common, is, hey, there are a handful of things that we would consider to be deal breakers if they're not resolved. And here they are, and we're asking you to fix them. Understand that the seller has the right to respond, and they can flatly say no if they would like to, or they may say, well, we can do these things, but we can't do that. It's just as common for them to say, well, we can do A, B, and C, however, we can't do D, so instead of that, we would offer to make an adjustment of dollars and cents of this much. And that can take on many different forms, and your realtor is going to help you navigate that. So the inspection notice is really a list of things that need to be taken care of before the deal can move forward. Next is appraisal. And your lender is going to be working towards getting the appraisal ordered right away. They move very quickly to get everything done. Understand that all of these things from here to here, these cost you money. This is earnest money has to be paid to the closing escrow account. The title commitment incurs a real charge. The inspection itself is going to cost you money, and there may be multiple inspections. You may have a septic inspection or a well inspection. You may choose to do a radon inspection, any roof inspection, any number of specialty items above and beyond the regular inspection. And then the appraisal itself also has a fee. And we have seen lenders charge, I've seen some above $500. It just depends on the lender, okay? So once the appraisal is ordered, you've definitely spent a little bit more real money of your own. You have 25 days to get the appraisal, or if there is some issue with the appraisal. Let's say it didn't come in at high enough value, or maybe the appraiser says, hey, you need to fix these 4 items or whatever, which is can happen sometimes, especially if it's a government loan. They have more requirements, and the appraiser may be the one to identify what needs to be taken care of. So the appraisal, you have 25 days to let the seller know if there's some kind of an issue with that. We see the repairs demanded by the appraiser all the time. It's not anything to get too upset about. We just have to handle it. We just get a plan in place and get moving along. Closing date is a day that we try to put down. We are. This is where we feel confident that we can close by. We do our best. We work with the lender to say, how soon can we get this done? I'll be straightforward with you and tell you that sometimes the closing date changes. I would say a significant amount of the time closing dates change. That doesn't have to be a tumultuous thing as long as everyone agrees to modifying the closing date. If you're going to extend closing by a significant amount of time, I would strongly urge that you have an amendment made and drawn up that actually officially extends the closing date. Some folks just kind of throw this to the wind and say, well, we're going to close next week. We'll just sign the amendment later. Well, there's a risk there. You need to understand that once you've passed that closing date, if you've not signed an amendment with the other side, they could choose to walk away from the deal and sell the home to someone else. Likewise for buyers, they could, at their own expense, choose to walk away and do something else because effectively the contract is ended because the closing date is passed. So closing dates sometimes change, but take them seriously. Hopefully I've brought up some answers. Hopefully this is a good place to start some discussion. If you have questions, please give us a call. We'd love to talk to you. We'd love to help you as we move forward in helping you buy or sell your next home.